Justices of the Appellate Division, Fourth Department, hear ye, hear ye, hear ye. All persons have business to do before this court, withdraw and move here, if their attendance, and it shall be heard.
Thank you. Please be seated. The first case out for argument today is case 525, People versus McLeod.
Good morning, Your Honors. Can you hear me?
We can hear you. Very good. Can you hear us?
Yes, thank you, Your Honors.
Proceed, counsel.
Brian Schiffrin on behalf of Edward McLeod. In point one, we urge that it was reversible error for the court to refuse to give a missing witness charge as requested with respect to Ishnek Jones. Ms. Jones was knowledgeable about material facts in this case because she was the only victim of the crime who did not have her eyes covered by duct tape. She was, as a victim of the crime and the niece of a second victim of the crime, she would be expected to testify favorably to the people, and as indicated by the fact that she was on the people's witness list and had given a statement to Detective Bauman, she was available to testify. Thus, the three prima facie requirements for missing witness charge were met, and the burden fell to the people to show why the charge should not be given. The rationales by the court for denying the request do not withstand review. First, the court held that Ms. Jones was not under the control of the people because she had not been subpoenaed and not given a sworn statement. But the Court of Appeals in both Gonzalez and Savignon held that whereby status of a witness, in this case legal status and victim status, she would be expected to testify favorably, that constitutes the requirements of control.
Counsel, but did you object at the end of the people's case? Did the counsel, did they say anything? After the people
No, in terms of
rested?
timing, Your Honor, no. The court, after denying the request for three different grounds, after the instruction during deliberations, added a fourth ground that it was not a timely request. The earliest the request could have been made in this case was at the end of the people's case because she was on the witness list. Instead, the request here was made later when the defense rested during jury
But if she was on the people's witness list and when the people rested, there could have been, an
Absolutely.
objection.
That's correct.
Or defense counsel could have subpoenaed her. There was some reason why that didn't occur?
The Court of Appeals, yes, Your Honor. The Court of Appeals in People v. Gonzalez at page 428 expressly rejected the equally available requirement. I'll get back to timing in a second. I'm going to answer your question about equally available. When a witness is expected to, Court of Appeals in Gonzalez, when because of her status, a witness would be expected to testify favorably to the people, the equally available rationale does not apply. That's the holding of the Court of Appeals in Gonzalez, the leading case with respect to missing witness. Going back to the timing request, there's no question that the request could have been made and should have been made at the conclusion of the people's case when the people rested. Instead, it was made later. But it was made at a time where the people then could have called Ms. Jones as a rebuttal witness, both to rebut the testimony of Mr. McLeod that denied his participation in the crime and to bolster the testimony of the only witness, Rocky Jones, no relationship to Ms. Jones, that Mr. McLeod was one of the perpetrators. Mr. Jones testified under a plea agreement and testified his testimony was challenged. He had changed his version of events. In both People v. Robertson and People v. Bedine, the first and second departments held in these situations where there was an opportunity to call the witness as a rebuttal witness, there was no negative problem suffered by the people, and therefore it was error in those cases, Bedine and Robertson, to not reverse, even though it wasn't made as soon as it should be. In both those cases, they held in the interest of justice, they should have been the request was improperly denied, and the reversal. As you pointed out, the people had the opportunity to call her as rebuttal. They didn't argue it was untimely, and perhaps the reason they didn't call her is that when Detective Bauman testified, he spoke to both Ms. Pointer, who testified she never saw the faces of the perpetrated because she was covered with duct tape. And Miss Jones, Detective Bauman got a description of the perpetrator as having a facial tattoo, which is inconsistent with the testimony of Rocky Jones. Therefore, there's a good reason they didn't call her, because it could have hurt their case. And that's why it's so critical that the missing witness charge was given in this case, because it wasn't harmless. The only testimony from a witness saying that he was the perpetrator was Rocky Jones, who first gave a different version, then got a deal where his murder charge was reduced to manslaughter. The only other evidence purporting linking Mr. McLeod to these crimes was DNA evidence, but there's problems with the DNA evidence. There was a piece of duct tape that was brought to the house by Rocky Jones and removed by the police at a time, and that was never in the house at the same time that Mr. Beasley, one of the residents of the house, was there, and yet Mr. Beasley's DNA was there on that tape. There was a glove with Mr. Law, the decedent's DNA inside the tape. These problems indicate that the evidence was mishandled and therefore compromised its integrity and rendered the DNA results unreliable. It should be pointed out, one of the police witnesses testified that he did not change gloves between handling each item of evidence. That's how you get transference. So it was critical for the jury to hear that they could draw an adverse inference from the failure to call Miss Jones, who again would be naturally expected to testify. She was there. She gave a statement to the police. She was on the witness list. They must have thought she was competent to testify. I'm going to go to the age issue because that was the third round by the.
Let's get to how old was she at the time of the event?
She was a week short of 7 at the time of the event, and she was 7.
7 years old. A week short of 7 years old.
That's correct, Your Honor.
Okay.
And she was 7 at the time of trial. This court in People v. Scott, affirmed by the Court of Appeals in People v. Scott, I cited in my brief, held that it was proper to allow a 4-year-old to testify when the 4-year-old demonstrated to the court that she was competent to understand what truth.
Would it have been required, do you think, to demonstrate that witness Jones was also competent at the age of 7?
The burden at this point was on the people. The reason that burden's on the people.
But I'm not talking about burden. I'm just saying, do you think it's appropriate that at that age there would have to be a finding initially of the witness's competence before testimony could begin?
Yes, but if in this case, what should have happened when the request was made with Miss Jones is she should have been brought in. If there was and the court should have asked the questions to determine whether or not she was capable of giving sworn testimony. But what the court shouldn't have been able to do was simply summarily say, nope, she can't give. She's 7, and therefore she's not a competent witness. There's a presumption, but it's a rebuttable presumption that witnesses under age 12 cannot testify. But there's numerous cases, again, many cited in my brief, in which witnesses under age 12 have been found to be competent. The fact that she was a
does the presumption shift the burden?
No. What the presumption means is that at that point, quote, bring the person in. The presumption.
I'm sorry, say that again, counsel.
But the presumption means that that she couldn't testify until as a sworn witness, unless and until it's determined that she's capable of telling the truth. But the presumption doesn't.
If the presumption, counsel, if the presumption is that she's not competent, does that have meaning in this argument?
It means
in terms of burden.
I respectfully no, because the presumption is she's not competent to give sworn testimony. She could have given an unsworn testimony, but there's no presumption about that. And again,
was that argued?
I'm sorry.
Was that argued?
No, Your Honor. That was not argued. But what was argued is that she was there and she was capable of giving testimony, and that she was on the people's witness list, which indicated that they believed she was competent. It's an improper switching of the burden on missing witness charges to say, well, this is your child witness. It's the burden of the defendant to bring in a person who they don't even have access to this child. That's why the burden is on the people to begin with in this case, and that's why the equally available rule doesn't apply. This is a child who they couldn't. I mean, the attorney says on the record at page 1330 record, I don't even know how to subpoena this child. I don't know where she is at this point.
Counselor, you're making this argument, but you don't have a case from the Court of Appeals specifically addressing a missing witness charge with a presumptively incompetent child witness, correct?
That's correct, Your Honor. And I don't have one going against me. This is on. It's unusual circumstance. There's no question about that. The people don't have a case on that issue either. But
Well, counsel, I'm gonna suggest to you that your time is getting thin and you have other points. Is there something you want to hit before your time expires?
yes, on point two, Your Honors, the DA improperly sought to bolster the significance of the DNA evidence and to refute Mr. McLeod's testimony. With respect to the DNA evidence, in part, the DA argued without objection that because the other 4 people were excluded as a source of the DNA and Mr. McLeod wasn't excluded, that confirms that they used the word, confirms that he was the person who put the duct tape on Ms. Pointer. That is an absolute mischaracterization, distortion of the testimony. The testimony was he wasn't excluded, and there's a 1 in 5,500 chance that a random person would have that DNA. That is the same type of error that this court in Rozier and Jones held to be reversible error absent objection. That wasn't, as pointed out in my brief, that wasn't the only distortion with respect to DNA evidence. The DA argued that the presence of Mr. Beasley's DNA, even when he had no contact with that tape, didn't mean it was mishandled, but rather that was normal and to be expected because it was his house. Again, no testimony. He became an unsworn witness with respect to the jacket. McLeod testified that was his jacket and he loaned it without any witness or evidence to support this. The objection was overruled when the DA argued that this jacket belonged to Mr. Law. That was, again, testimony not supported by the record, total speculation. And the combination of all this gave the jury a distorted view of the quality of the DNA evidence in a case where otherwise they were relying on the incentivized testimony of Mr. Rocky Jones, and that could explain the verdict. For those reasons, we urge reversal, Your Honors.
Thank you, counsel.
May it please the court, Michael Hillary for the people. With respect to the missing witness charge, Your Honors, this court has to review that matter in an abuse of discretion standard. The question is whether the court abused its discretion in denying the defense request for a missing witness charge. And in the circumstances, I think it was a very reasonable exercise of the court's discretion. As the court has already indicated, the witness was very young. She was just shy of her 7th birthday at the time of the crime. She would have been 7 at the time of trial, so she was presumptively incompetent. And I understand counsel's point that doesn't foreclose the possibility the court could have had a hearing to determine whether she was fit to give testimony from the stand. However, that was not the only basis of objection from the people to calling the witness. Her testimony was cumulative in the circumstances because you had the ear witness and Selena Pointer to everything that happened. And you had the testimony of Rocky Jones, who was a co-criminal with the defendant in this matter.
The aunt, wasn't the aunt blindfolded?
Yes, she was. Yeah, she heard everything, but she didn't see it.
And only the little girl is the only one that saw everything.
She's the only witness besides a co-defendant in the case, yes, who would have seen the event. So I understand the point that—
My question is on the harm. I want you to address the harmlessness issue of that. Was that error harmless? I
believe it was, given the proof here. And I believe that the DNA evidence is much stronger than defense counsel suggests it was. And to just kind of branch off very briefly into the second point, the mischaracterization that defense counsel is citing with respect to that DNA, I think is very mild in the circumstances, given the fact that the prosecutor was tethering the inferences that she was drawing to the calculations of probability with respect to that DNA and the extent to which we established the likely connection to the perpetrator. But yes, the evidence here was overwhelming. Take, for example, the glove that was found in the garbage tote several houses down from the crime scene. It had Mr. Law's blood on it to a very high probability. And inside the glove, to a very high probability, was the defendant's DNA. We also know that the defendant's DNA, to a very high probability, was found on the duct tape that was taken from the kitchen garbage. So there's, I think, compelling DNA evidence to establish the defendant's tie to the scene. In addition, when we went to the defendant's house, the police did, they found duct tape about the house and they found a pair of sneakers, one of which had duct tape on the bottom of it. I think the evidence was pretty compelling, and if the jury credits Rocky Jones's testimony, which they did here, I think that solidified the people's case in addition to the testimony, of course, of Ms. Pointer. So I think going back to the missing witness charge, the defendant should have raised it earlier. He should not have waited to raise it until the charging conference. That has real repercussions to the people. If now the people are in a position to have to call this witness at the risk of there being a missing witness instruction, that signals something to a jury when suddenly, after the defendant has testified, the people are now putting on another witness. Even though it's not necessarily in rebuttal to the defendant's testimony, it has a look and it has a feel for the jury. So there are repercussions. It's one of the reasons why courts require the timeliness of these kinds of motions and objections for fair play to both sides. Yes, she was on the witness list. That's fair dealing by the people. If we don't put her on and we decide to on the list and then we decide to call her, that could be unfair surprise. So it can't be a sword and a shield to say that we had her on the witness list.
Well, the witness list something that is exchanged to tell the other side, we are calling every one of these people, or is it simply you're on notice that this is the field of people that at this point we know may be called during this trial?
That's precisely it, Your Honor. We want to do fair dealing with the other side. We want them to be aware of everybody that potentially could be called. We're not sure who we're going to call, but they ought to know about it. And that's what we did here.
Any further, counsel?
No, Judge.
Thank you, counsel.
Thank you.
Case 526 and 527, people of the state of New York versus Evans. Counsel, can you hear us?
Yes, it was a slow connection, Your Honor. Can you hear me?
We can hear you fine. Please proceed.
Okay. Paul Skip Lazier of counsel to the Wayne County Public Defender for David Evans. With respect to the speedy trial issue, I want to point out that this was a pre-amendments case. It's straight up Bay. And in this case, there was simply not due diligence done by the people. There was curriculum vitae and proficiency results for 2 analysts that were not disclosed in the initial COC.
Was the due diligence, counselor, alleged in the 3030 motion before the trial court?
I'm sorry, say that again?
Was the lack of due diligence alleged in the 3030 motion before the trial court as the reason for the 3030 motion?
Well, if it wasn't stated outright, it was certainly part of the entire argument that was being made. Is that, in other words, the people did not disclose this stuff. There was no reason offered for why they didn't disclose, and no explanation for why it was late. That all adds up to due diligence. I don't think they had this, defense counsel had to use those 2 words.
Yeah, but they did. It's pretty clear in the record they didn't. But let me ask you this: are you referring to the original disclosure or the supplemental disclosures?
All of the above, Your Honor. What they did was they stated ready with the initial one, and then they kept doing supplementals to disclose the late materials, but they never answered ready validly because the first one was not valid. The first certificate. So, I mean, the things that they didn't disclose were obvious. They were within their control, perhaps with the exception of the Newark Police Department report. But that is up to them to figure out. It's not up to the defense to make, their disclosures timely. It's up to them to either do it or explain why they couldn't. And they've never explained why they couldn't for any of the things that were disclosed late. And since that initial certificate of compliance was invalid, there was never a readiness, validly offered. The people say that there were all these exclusions for time, but none of them apply because the defense never caused any of the disclosure delay or any of the reason that they weren't ready. So there were 542 days of includable time here.
The court charged 40 days to the people, right?
Right. But that's taking into account all those exclusions, and the exclusions simply didn't apply because nothing the defense did stopped the people from answering ready after a valid COC. By the way, there were plenty of notifications by the defense, so it's not one of these gamesmanship situations. Defense counsel all along was saying that what they didn't have, and people finally disclosed it with no explanation for why it was late. I'm going to move on to the second point, which is
Counsel, not to throw you off your argument, I certainly don't intend to do that, but would you mind addressing point 3 ahead of point 2?
That's fine. That's fine.
Please do.
Yeah, there was no evidence of 3 months duration for predatory sexual assault. Working back from the most recent August 8th allegation, there were 3 other incidents that could qualify, but one was an August 6th oral sex incident, and then there were 2 other incidents before that the complainant could not say anything about what the timing was. Now, this court and others have held that if there are markers that associate with the events, then the timing can be gleaned from that. But the only marker here was that.
And when you're talking about a marker, you're talking about things like it was right after school began, or right after summer recess began, or something along those that triggers within the victim a time frame which we can then infer dates, right?
Exactly, and you pretty much nailed it right there, which is that they occurred during summer school. Well, even assuming that summer school began May 8th, which would have been 3 months before the last incident, it's almost impossible to think that it occurred before May 8th and still was summer school. And notwithstanding that, it was the people's obligation to say when summer school began in order to have that marker mean something. So more likely it occurred during the summer, sometime in June or July, which would not have exceeded the 3 months required by the statute.
Thank you, Counsel. You can proceed to 2 if you'd like at this time.
Yes. There was what I'm going to call the purple toy evidence. There was specific testimony that it was used on KM by Mr. Evans, and it was tested, and there was no DNA from Mr. Evans on that. So that tends to establish, or it tends to prove that the complainant was lying about that incident. Now,
is that collateral?
Well, it's not collateral when it goes to the credibility of the main witness. In other words, if she lied about the toy, she could have been lying about other allegations that she made.
Well, it clearly goes to the credibility, but is it an item that needs to be proven to sustain the charge in the indictment?
No, but it doesn't need to be. It's not collateral because it goes to her credibility overall. So the people's argument that they didn't charge her anything about that incident is irrelevant, because if she's lying about that, she could have been lying about the charged items. And that's the point of the non-collateral rule with respect to credibility of the main witness. And that's been held over and over by this and other courts.
Was that harmless error?
Counsel?
The requirement.
Counsel, I'm going to interrupt you for a second. You were frozen for a moment there. There was a question from one of our panel members.
Was that harmless error?
Yes. I'm sorry to see that we're frozen. Go ahead.
Why don't you ask the question again?
Was that harmless error? Yes.
Harmless error? Okay, so all we have here in this case is allegations by KM. There's very little other proof of what she said. And so that's why, this credibility question is essential. If she's lying about that, why would the jury necessarily believe any of the other things she was testifying about?
So
That's why it's not harmless.
You don't think the testimony about the condom, the testimony of the brother and all those things aren't all contributing to the credibility here?
They are contributing, but there's no date with respect to the condom. We don't know where that came from, when it was deposited in the garbage. And Noah's testimony was, it was admissible because it tended to prove the people's case, but it certainly didn't establish anything. And that's why it's not harmless, to exclude the evidence of the toy. And besides that, any of the questions about timing or et cetera would go to weight, not admissibility of that evidence.
Very good, counsel. Anything further?
No, thank you.
Thank you, counsel.
Good morning. May it please the court. Catherine Menacotz for the Wayne County District Attorney Respondent. I start by asking the panel if there's something you'd like me to directly address before I begin.
Begin your argument.
Thank you. With regard to the 30-30 issue, I think the people did establish good faith and due diligence as that standard was established in Bay. Bay was decided while this case was pending, but those principles were still used to determine on a case-by-case basis. In this case, the people established that in their response to the motion that there was voluminous discovery materials, that the prosecutor had not announced readiness until she had reached out to the police, 911, the lab, and received, from civilians, received video from the burned dairy, from the police department. All of those items were turned over after she requested those things. The items that were missing, the question I suppose is, would it have been apparent to someone in the exercise of due diligence? In this case, Your Honor, I would say not necessarily. Given all the other information that was imparted and the lab reports and all of this information included in there, which I believe the prosecutor said was over 200 pages of lab reports and the ensuing reports, as soon as she heard that those things were missing, as soon as she was informed, which was not until many months later, which again goes back to, although defense attorney had said early on in her statement that she didn't have the lab stuff or words to that effect, there was never any mention specifically of the CVs and those reports. As soon as the prosecutor became aware, she turned them over. I'm sorry.
But didn't the prosecutor know ahead of time that she was going to need that? Couldn't the prosecutor have requested it?
I believe when she requested all of the New York State Police materials, she believed she received all of them. So the question is, it's a mistake, right? So when we're talking about due diligence of a prosecutor, we make mistakes. It's not the perfect prosecutor. When they became aware, again, we're talking about defense counsel not realizing they weren't there either. What would have been obvious to the prosecutor, I'm not shifting the burden, but we're talking about whether it's obvious. When you sit down to prepare for trial, I don't have the CV. It was asked for, it was turned over immediately. And that's one of the things in Bay, which is, talked about in terms of due diligence. And I always say when arguing this that, and it's said in Bay, prosecution doesn't operate in a vacuum. While this prosecutor is handling this case, she's handling almost every other trial case this court has ever considered. So we're talking about, there's a case out of the second department, which talks about Suffolk County hired 20 people to just do discovery. We don't have that in Wayne County. We're lucky we have enough prosecutors to handle what we have. So the court taking that into consideration, that court, which handles almost every trial with that attorney, has to be given some deference to determining that prosecutor acted in good faith, given the situation in Wayne County. It's not included in Bay, but I think when we talk about that second department case that I was talking about, due diligence there is hiring 20 people to just do discovery on top of the attorneys. So in this context,
the lab report relating to the vibrator, was that turned over timely?
oh yes, We're talking about the CVs
Right.
and their.
I just want to make sure.
Yes.
Because that would be my next question.
Other than that, I'll move on. I think that the people responded in their motion, establishing due diligence, and the court agreed under these circumstances. Okay. I will turn to point 2, which is the lack of DNA evidence. I disagree that it goes to the complainant's credibility in this case. It's never been established why it would be expected that DNA would be on that item. Just as much as if I'm standing here and I'm touching this podium and I walk away and there's no DNA on this table, would that ever discredit me from saying that I had been here? You have to have some relevance. Would it be expected to be on that item?
Well,
There was other DNA.
if he inserted the vibrator into her,
But
the
when?
12-year-old girl, it would be expected that his DNA would be on it.
But when did there were other people's DNA in there, could have been used without getting too graphic, Judge. It could have been used many times after, washed, cleaned. It would go to whether there was DNA on there, but to discredit a witness because there's no DNA, one does not follow the other necessarily. If it was the same day, I might agree with you. Sorry, my mouth is very dry. Just a second.
Why don't you hit point 3 when you get a chance?
Yes. Point 3. I will say that in this case, the evidence was presented, given a ruling by the court on what the people presented as Molyneux evidence, which arguably was not Molyneux, as this court had a similar case in People versus Young, which I cited, wherein the witness was able to give the earliest start time based upon the defendant had shown her pornography around Thanksgiving. Defense counsels objected to that, and the defense counsel herself came up with a compromise and said, I have no objection to you directing the witness to November 21st, which is what the prosecutor did. So that's the beginning time. The prosecutor asked the witness, did these things begin around November 21st of 2021? The answer was yes. Now, the prosecutor is trying to keep in mind the court's ruling that she could not go to that outside time, which this child used as her marker. I was shown pornography on a phone around Thanksgiving 2021. I'm paraphrasing based on what the prosecutor said. And the court offered a compromise. And then the defense counsel said, I have no objection to you leading the witness to that date to avoid bringing out this marker. So given that, prosecutor directed exactly like that. The witness responded yes, and then described things. She couldn't say what time, but that was the outside marker. So I asked the court to consider that. Yes, it would have been better if she had been able to say this happened, but she was not able to do that. So given the court's ruling, given the defense counsel's specific request, I believe that that has met the requirements, legal sufficiency of over 3 months.
Anything further, counsel?
No, Judge.
Thank you.
Thank you. I'm sorry, I was losing my voice.
No, that's quite all right. Happens. Case 529, People versus Crumpler.
Good morning, Your Honors. Kurt Lunkenheimer, Pro Bono Counsel for the Monroe County Public Defender's Office on behalf of Shrita Crumpler. May it please the court. Your Honors, before I go into some of the issues with the 3 prongs of the DVSJA matter here presented, I just want to point out this is a slightly unusual case. I think it's fairly new. In my readings, I haven't come across a case that involved a lesbian relationship. So I think it has to be looked at as slightly differently, and that has to be taken into effect, especially considering the fact that we believe that the trial court and the people have applied like antiquated, outdated social norms to this situation. They're applying like heterosexual stereotypes to this lesbian relationship. As Lee Goodmark in her article, I think we cited when is a battered woman and not a battered woman when she fights back. Lesbians, I guess, it's been studied that they have an unfair burden. They're pushed to have put more evidence to meet their burden than males and other people with a heterosexual relationship. Especially secondarily, it's been proven, or the studies have shown, that battered lesbians are constrained or more so from reporting their abusers, and they often want to protect their abusers. In addition, in this case, Ms. Crumpler was, I think, roughly 10 years, if not more, older than the victim and she was bigger than her, and that has to be taken into account. But size and age do not always matter. I think that was testified to by Dr. Cerulli, the expert that testified at the lower court, and also has been acknowledged in the People versus Adimondo 197 83rd 106.
Counsel, one of the first things I think that needs to be established is that the defendant was a victim of substantial abuse at the time of the offense,
Yes.
right?
Yes.
Specifically, what are the examples in the record of that substantial abuse? As I read the record, one has to do with the kicking of a cast, another has to do with relating to her Crohn's disease.
Yes, Your Honor. And first, I would
If
definitely.
you could articulate that a little more clearly to me as to what that was.
Yes, Your Honor. I want to first acknowledge that Ms. Crumpler believes that this is a mutually abusive relationship. This is not a one-sided abusive relationship. Ms. Crumpler acknowledges that she was physical with Ms. Keels, but also, as the testimony and I'll go into, Ms. Keels was providing coercive control, like psychological abuse, in addition to physical, because there's testimony about that. First, we have as to the coercive control. There's testimony about a curfew instituted by Ms. Keels. That was due to Crumpler's testimony, not only in the interrogation video, but also, I believe, at the trial court. And also is corroborated by the fact that Ms. Keels was waiting up for her that night, well after midnight. What's the reason for that? Well, that shows that she's in control. She's kind of overseeing her, monitoring it. In addition to the coercive control.
The fact that, I want to be clear about this, what the argument is, you're saying the fact that she waited up for her meant that she was in control.
It shows an example of the coercive control, that there was this relationship where she could have gone to bed. She could have left. If she truly wanted to leave that relationship, leave that house, she could have left before Ms. Crumpler came out. But for some reason, she stayed up waiting for her, waiting for that confrontation. Your Honor, I think the other evidence of coercive control would be some of the text messages that were referenced by Dr. Cerulli, including also Sharita Crumpler's testimony, or in the interrogation video. Mr. Porter's affidavit, which I can get into a little bit, references how he felt that based on his observations of the relationship that Ms. Keels was kind of pulling Ms. Crumpler away from her family and exerting more control over her. And in fact, and also, as I said, I think there's some text messages that Brianna mentioned that do that as well. Going back, I think there's also the slashing of the tires by Ms. Keels of Mr. Crumpler's car, which is corroborated by the police report that Ms. Crumpler filed, in which she highlighted that it was Ms. Keels. There's the ramming of the car, following Ms. Crumpler behind her, thinking that Ms. Crumpler was with some other female, maybe cheating on her, and she rammed her car. In that instance, I know it's not documented, I think, in a police report, but it was confirmed by Ms. Keels' mother at the DVSJA hearing, where she said she paid the damages caused by her daughter when she rammed the car. Again, Mr. Porter's affidavit, which Ms. Crumpler feels was improperly discredited by the trial court. We think that when it was offered into evidence, there was no hearsay objection. The only objection was relevance. And so I think that argument has been waived. And I think, look, most witnesses, outside of maybe a few of them, in any instance are biased one way or the other. He obviously had a relationship with the family, but I think it's not evident that affidavit was coerced by Ms. Crumpler. If it was, it probably would have been more detailed. It probably would have been more damning. But Mr. Porter's affidavit does talk about instances of violence between the two individuals and the bad situations. And as I said earlier, the coercive control.
Now, I think you'd acknowledge a lot of what you're relying upon is the testimony of your client, the defendant. The court below had an opportunity to view that witness, and the court below made a determination that that testimony was not to be credited.
Yes.
As you know, very often we have to rely upon the trial court who has an opportunity to view the witness and make judgment calls about credibility. What's your position on that?
Your Honor, I think under People versus Jasmine, you're supposed to provide an independent review of that credibility determination. You don't necessarily have to defer to it. Obviously, it comes into as a factor. But I think, and some of this has to go to the unfair burden potentially placed on Ms. Crumpler as a lesbian, but I think she is corroborated. That broken cast instance you talked about, they went to the PSI and they asked about how she broke it and involved, I think, a bouncer at a bar. Well, Ms. Crumpler's testimony, if you look at it, was that Ms. Keels broke it again when it was already in the cast. So I don't necessarily think that's an inconsistent statement. I think it's just an added part that was maybe left out of the PSI. I think that you have to look at her credibility. In that interrogation video, we have to go back into time and when it was done. She thought Ms. Keels was alive, right? This is her partner. They're in a relationship, lesbian relationship. I believe the evidence shows that Ms. Keels was also an abuser of her. She's motivated to protect her abuser, but she's also potentially protecting her partner who came at her with a knife. So she's in that instance. She thinks she's alive. She doesn't want to get Ms. Keels in trouble. And she eventually says that multiple points at times. In addition, she obviously was a victim of physical trauma. It's clear, I don't know exactly how, whether it was through a fist or something else. She had a broken orbitable bone. So you have this factor that this physical trauma, this emotional trauma of eventually losing her, trying to protect Ms. Keels. It goes to why the interrogation video has these inconsistencies in the changing story. So I think when we finally get to later on in the interrogation video, she is more consistent. And as I said, I think some of her testimonies corroborated by the damage to her and the images that have been provided in the evidence at the lower court. I think, as I said, the slashing of the tires, the ramming of the car. Another one is the screwdriver incident that has been discussed in the hotel room with Miss Williams, which she testified at the sentencing about that instance where Miss Keels.
So even if you meet your first two, what of the third prong? What about the excessive sentence? She got a 17-year sentence, but it could have been 25 years.
Yes, Your Honor.
How do you deem that to be excessive?
Your Honor, I think we have to look at the sentence at the time it was given, right? Look, the trial court, I read it again last night, did a good job of explaining the situation, explaining it. And I have to acknowledge it was lenient. It went from 25 to 17. But the point of the DVSJA is to provide a new paradigm, like a new lens to look through it. At that time of the sentence, while the judge was lenient and factored into the into the sentence, the relationship that Ms. Crumpler was never charged with murder. She was only charged with manslaughter and sentenced under 17 years. There was no testimony or evidence about or directly put forth, like including expert testimony, that she was a victim of a domestic violence. But now we are putting that forward. So if you find that she was a victim of substantial domestic violence that had a significant contributing factor, you have to look at her then, that she is also a victim. While an abuser, she is a victim. And in that circumstance, I think that the 17-year sentence does become harsh and excessive. It should have been lower at that time. And if the trial court, the sentencing judge had seen that and heard that evidence, he would have come out that way. And hence the 17 years is excessive.
So you're saying that it's not enough that the trial judge took into consideration appropriately the relationship at the time of sentencing. You're saying that the trial judge did not specifically have in mind the defendant as a victim of domestic abuse, and that would have factored additionally into the sentencing, which could have resulted in an even lesser sentence.
Yes, Your Honor.
Very good. Anything further, counsel?
Nothing further, Your Honor. Thank you for the time.
Good morning, Your Honors. May it please the court, Lisa Gray on behalf of the people. Just at the outset, obviously, this court is aware it does have plenary review power to make its own assessments of the record and the factual findings. I would urge this court to defer to the hearing court's credibility determinations with respect to the corporeal evidence that it heard at the time of the hearing. I just want to address initially, though, the argument that my opposing counsel made with respect to this particular dynamic between Ms. Crumpler and the victim in this case. At the time of the hearing, Ms. Crumpler could have called an expert to dive more specifically into same-sex intimate partner violence. The expert that they called addressed more broadly, generally intimate partner violence, and talked specifically about these two individuals and the dynamic of that particular relationship. So to the extent that perhaps the paradigm through which the court addressed their relationship, opposing counsel calls it an outdated notion. Well, Ms. Crumpler was in a position to perhaps call a witness to address the particular dynamic of a same-sex intimate partner relationship, and she didn't. So Dr. Cerulli addressed specifically the dynamics of this particular relationship and the evidence taken as a whole did not move that needle beyond or to get to the preponderance of the evidence to establish either prongs 1 or 2. And the court addressed each of the incidents that presiding justice you mentioned. So for example, the tire slashing incident that occurred in 2011, that predated the relationship between Ms. Crumpler and the victim in this case. So that in and of itself basically put that incident out of the box as far as the court was concerned. And that, I think that was appropriate. It predated the relationship between the two of them. It didn't play into whether or not Ms. Crumpler was suffering abuse at the hands, substantial abuse at the hands of the victim in this case. With respect to the January 2014 cast kicking incident, that was uncorroborated. Perhaps Ms. Crumpler could have put in medical records to corroborate the fact that her ankle had been rebroken. I think in her testimony, she said she had to go back to the hospital and get it recast. There were no medical records entered into evidence to suggest that that is the case. There was the July 4th, 2014 choking incident where Ms. Crumpler testified that she had come back after her curfew, and the victim in the incident was the victim in the case was upset. Again, that was uncorroborated. Defendant admitted that she bit the victim, she locked the victim out of the house, and that she refused to speak to the police when the police came. So really the only incident that the court gave some credibility to was the 2012 incident where the victim struck defendant with her car. And that was some evidence of jealousy on the part of the victim towards the defendant. But again, the evidence together just that it did not force that needle to get to the preponderance of the evidence. This was a mutually combative relationship. The violence was bidirectional. Dr. Cerulli said that as much. And in fact, I think at one point during her cross-examination, Dr. Cerulli said, listen, they were both afraid of their own behavior and ratting out their own partner. So again, there was this relationship was violent. It was mutually combative, but there's nothing in the record that would really get the defendant over that hump of getting into the preponderance of the evidence with respect to establishing prongs 1 and 2.
Do you want to address the sentence, Kelsey?
Yes, Your Honor. The 17-year sentence was not unduly harsh or severe. As Justice Ogden pointed out, the maximum was 25, and the time of sentencing, the court did take all these things into consideration.
What about counsel's argument that clearly the judge did not take into consideration the specifics of the relationship here, right? And the possibility that may have impacted the sentence. Does that argument hold any water? In other words, they got to 17 years based upon what he considered, but he didn't consider everything.
I think he considered what he was required to consider. He sat through the trial. He heard the evidence as it came in regarding the events that transpired that resulted in Ms. Keel's death. And based on defendant's criminal history, the nature of the relationship, he imposed what he thought was a fair sentence, taking aggravating and mitigating circumstances into account.
Thank you, counsel.
Thank you.
Case 530 in the matter of Tishawn B. Counsel, can you hear us?
Yes, I can.
Very good. We can hear you very clearly. Please proceed.
Good morning, Your Honors, and may it please the court, Roxana Herod of the Legal Aid Bureau of Buffalo on behalf of the child, Tishawn. I'm just here. I would like to rest on my brief, but I am available to answer questions the court may have about how our client is doing.
How is your client doing?
Our client is doing very well. He is with the guardians and absolutely thriving.
That's good to hear. Anything further, counsel?
No, Your Honors, if there's nothing else.
Thank you.
Right, thank you.
Case 531, Saraceno versus Mazikowski.
Good morning, Your Honors. May it please the court, Gina Salino for plaintiff appellant Nicholas Saraceno. The crux of our argument is that plaintiff was not hunting within the definition of Department of Environmental Conservation, section 197.2.
We skip over any argument that the property was suitable for hunting, right? It was a hunting area. People hunted there all the time.
It was, but I mean, the area was also used for other things. They didn't just go there to hunt. There was a cabin, there was an apartment, a garage. They'd go there and do yard work. I mean, the defendant himself, when he was still living, he no longer hunted. He would just go and hang out. So it was also like a family gathering.
Mm-hmm.
So it was almost akin to a second home. But the main argument, and
The question that we're looking at is the question, is it sufficiently related to hunting? The activity that the plaintiff was doing was sufficiently related to hunting? Is that what we're asking? Or is that the proper question for us to answer?
Yes, and the court has expounded. Originally, they said there are certain activities that are black and white, but then the court started to expand it and looked at what the activities they were doing. So, for example, in Saga, the Court of Appeals looked at hiking. Hiking used to be something that would be considered black and white, and then they looked at the intent. In Saga, the plaintiff was hiking, took a break. I believe this is where they stayed on the bridge, and then their intention was to resume hiking. There is no intent on the part of the plaintiff that he was going there to hunt. He went there midday, 12:30.
Well, hold on. You're saying that there was nothing to indicate he went there for hunting. He arrived there, right, with a weapon that was loaded, that he knew that once he was there, he was going to discharge, right?
Yes, he had
Right.
a discharge.
He admitted that if he had come across game that was proper to shoot at, he was going to shoot at game. Having a weapon that's loaded, seeing game, if you see it, isn't that hunting?
Okay. First, addressing, yes, he brought the gun, the muzzle loader gun, which had to be discharged. That's the only way to discharge that kind of gun. He brought it with him. But when he gets onto the property, the testimony in the record, if you look at 106 to 109, he gets there, he goes in the cabin, then he gets on the ATV. Where is there any testimony that he brought the gun with him on that ATV? I just realized this as I was preparing, and I may be mistaken, but I can't point to where he had the gun with him. I know he did not bring the gun up with him to the tree stand. Furthermore, during that questioning by my opponent, in their answer, they never—
Wasn't the gun, and you know the record better than I do, so bear with me, but wasn't the gun retrieved by the people that came to take care of it? And wasn't the gun on the trail when they retrieved it?
Just to add to that, my recollection was 10 feet away from the tree at most.
Okay, maybe I'm wrong about that. I did admit, I just came up with that argument that I didn't think there was testimony he had it on him.
So let's move on from there though.
But then the statement of, I brought the gun with me, should I happen upon a deer? And our argument is, one, it was never pleasant affirmative defense. So we were prejudiced in preparing our client. But furthermore, if you actually look at the testimony, the statement, if I happen to come across one while I was grabbing the cameras, it's a conditional statement, past simple, with would, and a base verb. That kind of conditional statement is suggesting something that's highly unlikely to happen. He came there midday. Hunters go first thing in the morning or at dusk. He wasn't wearing any hunting equipment. He said repeatedly, it was not my intent to hunt. And it's defendant's job to prove as a matter of law that he was there, that he was hunting, that he was Pursuing, shooting, killing,
You know,
or capturing
a
wildlife.
moment or two ago, you started to go down the path of the environmental conservation regulations.
Yes,
And I've looked at that definition in the regulations. It also says, in every attempt to take. So it just doesn't have to just be a taking as defined under the law, but an attempt to take. And then that led me to look at the actual statute for the definition of hunting, which I believe says whether they result in taking or not. So you don't actually have to shoot. You don't actually have to take a deer. You just have to be hunting as defined in the statute, and it can be hunting whether it results in a taking or not. I don't know how you can claim that this is not hunting when he would have shot the deer and he has his weapon with him, given that definition.
I look towards his intent of why he went onto the property. It was the last day of the season. He brought the gun mostly to unload it because that's how you had to unload a muzzle gun loader. And the way he said, if I were to come upon one, he's going there midday and
When he went up there looking for his keys, didn't he?
he went
didn't
up the
take
tree
gun
stand.
with him when he went up to look.
Right.
He went up the tree.
Right.
Look for the keys.
Correct. The main purpose of his being there was to retrieve his hunting cameras. And in other cases, they look at other circumstances, the hiking, what they wanted to say was the hiking sufficiently related. They looked at the footwear. He wasn't in hunting gear. There is, defense argues about his blood alcohol content, that he had been drinking. Can't be drinking while you're hunting. Like it was the last day of the season, it's midday.
Wait a minute. You just said he wouldn't be drinking if he was hunting. Is that what you said?
Correct.
Okay.
I believe it's against
I
the law,
wasn't-
be intoxicated while
Yeah,
hunting.
no, I understand your point. I just didn't know if I heard correct.
Oh, okay.
Go ahead.
So yeah, I do think that we were prejudiced, but that not having that affirmative defense in the answer. But also, let me see. Looking at the intent in another case, what they did. The recreational intent, the activity of driving the ATV to relieve themselves. The Court of Appeals in Farnham said the whole point they were there is on riding those ATVs is because they wanted to relieve themselves. They had to use the bathroom. And the Court of Appeals found that there was a question of fact with regards to the intent. I think there is enough here to say that there is a question of fact when it comes to his intent, whether he was hunting or not. And may I just ask a question? Because I did see where they expounded or didn't expound, but in the Department of Environmental for fishing, and it said something to the effect of, and also related to the act of retrieving a fish. So did I miss part of the
I'm looking at the
definition?
definition of hunting. In the
Okay.
statute, not the regulations. And very honestly, Ms. Lino, I'm not entirely certain that you quoted the full language of the regulation because you didn't quote the language of the regulation. Also says every attempt to.
Right, and that's in one,
That's what I'm looking at the moment.
just for my, education purposes, it's for the 197.2. I just want to look it up when I'm done.
I'm looking at it, New York Environmental Conservation Law 11-0103, subdivision 10. Anyway,
Okay, thank you.
for my benefit, would you mind taking me to your view of the alternative basis for affirmance? The alternative basis for affirmance argued in the respondent's brief and argued in the motion below, which was even if you don't apply immunity.
Right.
There's no negligence here because the owner here did not create the alleged dangerous condition, which I believe is the missing or the defective tree stand, nor is there any evidence in this record of any notice, either actual or constructive. That's my understanding of the argument as an alternative basis to affirm.
Yes. So our argument that the defendant is not afforded the protection of general obligations law, and that because plaintiff is an invitee, he is owed a duty of care. The affirmative negligence, I believe you're referencing, Your Honor, is looking at the status of the plaintiff as he comes onto the.
No, Basso did away with status a long time ago, as you know.
Right, but they address the affirmative negligence underneath the status of a licensee.
That's for purposes of the immunity statute. That's the Davis case, I think, that I was on years ago about the strap and the affirmative negligence with respect to that. I'm outside the immunity now.
Okay.
Let's assume we find a question of fact as to immunity. The alternative basis for affirmance that has been advanced on appeal, as well as was advanced below in support of the motion, was that there's no negligence here. So that
Okay.
even if the statute doesn't apply, that there's no negligence here because the landowner did not create the dangerous condition we've alleged in the bill of particulars and did not have any actual or constructive notice of it. I'm having a hard time seeing why that's not a good argument.
The constructive notice is that he, one, allowed these tree stands to be erected on his property. They were on his property for over 5 years. He willfully did not do any inspection of the tree stands. He willfully didn't do any, didn't take any steps to ensure that they were properly maintained. As a landowner,
Case law from the Court of Appeal that says that a landowner in this situation has a general duty to inspect.
I think the landowner has to exercise reasonable care to disclose dangerous defects known to the possessor and unlikely to be discovered. He's the one who possesses.
Latent defect.
Well, he's the one that possesses the land. He's there more and
I'll
they're
take a look.
not invited onto the property.
I'll look closer.
Very good. Thank you,
All right,
counsel.
thank you, Your Honor.
May it please the court, Patricia Ciccarelli for respondent Laura Mazakowski as administratrix of the estate of Roger Mazakowski. First, I just want to briefly address, and boy, I really wish I had brought the record with me like that in hardbound copy, but I do believe, I do believe we pled the general obligations law 9-103 in our answer, which I guess I don't want to waste the court's time, but record page, let's see, it's in here. Maybe we didn't plead it, but it was certainly obvious through the extent of discovery that the issue was going to be raised. And in fact, it was raised in our response to plaintiff's bill of particulars. So I don't think there was any surprise there. Plus, I mean, just to go back to the original argument, the law does not require the plaintiff to be engaged in hunting. It could be an activity sufficiently related. And Ms. Salino said main purpose, and that is not the legal standard. The legal standard is not main purpose, but sufficiently related.
Let me ask you this then. If we use the phrase sufficiently related, would it have been enough if the plaintiff had shown up on the property dressed as he was, with a gun that he was going to discharge essentially for purposes of cleaning it, not for hunting, but to clean it? He had to discharge it somewhere. So he's on the property. That seems like a reasonable place to discharge it. If he was going there to simply discharge the weapon and retrieve the cameras that are put there for the purpose of hunting, right? Is that sufficiently related?
Well, I think a lot more was going on.
No,
To address your Honor's question.
If that was all he was doing,
Yes,
all right, is that sufficiently related?
absolutely. He's retrieving hunting cameras. He's at a hunting cabin. He lost the keys to the hunting camera, and the gun could have been unloaded. It's 52 acres of rural property. He could have walked out the back door and discharged the rifle. Instead, he pursues to hunt because the DEC reg doesn't just say you have to kill the animal. It very clearly says pursuit. And he admitted that if he saw a deer, he would have shot a deer. If that's not pursuit, I'm not sure what is.
I don't know if that's pursuit or not. It seems to me if you're just walking through the woods and a deer shows up while you're engaged in other things, it's not that you're pursuing a deer. You're not tracking a deer. You're not looking for signs of deer. You're going to do the camera work. And so I don't know if it is in pursuit of the deer. But we're certainly going to take a look at it. It's an interesting fact scenario.
But I just want to add, Your Honor, it's critical to look at other cases with similar fact patterns. And if you look at the Sabia case, in that particular, I bumped ahead to consideration. Let me back up. If you look at the case, and I believe it was Sabia, where they're on, or Hemingway, it's Hemingway case. That's so on point to this case. The boys are riding their bikes, an enumerated protective activity. They drop their keys or their money. They drop their money. So they crossed the tracks to retrieve the money they had lost while riding their bikes. I think that's analogous to this case. It's right on point. He drops his keys for the hunting cabin and he goes up to the tree stand installed on the property by the plaintiff and his brothers to look for the hunting keys from the hunting tree stand. And as far as any argument on his clothing, I mean, he's not out there in leather-soled, shoes and a suit. He's out there in, boots, jeans, and a Carhartt jacket. I mean, I think he admitted that he was hunting, and this notion of the season had ended, clearly the record is clear, the season had not ended. And when his brother was asked, was he hunting? His own brother, his hunting buddy, said, well, why else? He had his gun with him. I myself was going out to hunt when he got the call that his brother was injured. So any argument about the time of day is contradicted by
And
the
it's the
facts
last,
in
it's the last
record
day
as
of
well.
hunting season.
It's the last day of the season. And his brother said, we're all going out to hunt. It's the last day of the season. And that's why, his own brother, why else would he be out there? And my client, his uncle, said the same thing. Why would he have had his gun with him? And again, he could have unloaded the gun before he went out deep into the woods for the purposes of hunting. And on the issue of consideration, would the court like me to address that issue?
If you'd like to, feel free to.
Just on the issue of consideration, I think when I thought about this, I looked at the case law and there's the Sabia case, the Hemingway case. In both those cases, actual money was exchanged. In Sabia, people had to pay a membership fee, and still the court found that there was not a sufficient nexus between the person hiking on the trail and the individual paying a fee. In the Hemingway case, you actually had to pay a fee to use the lodge, but then when someone was injured on the slope itself, the court still said there was not a sufficient nexus between the fee to use the lodge and getting injured on the slope adjacent to the lodge. I cannot envision a situation where we distinguish this case from that case. It was very clear here by everyone's testimony, including the plaintiff, that he helped his elderly family member because he was an elderly family member. And he adds, and because he let me use his property. So that's a gratuitous, a thank you for your kindness. If we extend the law as Ms. Salino would have us do, well, first, then we're not strictly applying the statutory, we're not following the statutory intent. The case law is clear that the statute is to be strictly construed, and this honorable court would not be doing that if we go that far. But to carry it into like a day-to-day situation, that means if you ask your buddy, hey, can I drop my fishing pole in your lake? And he says, sure, and you decide to bring him a case of beer, no more statute. Now he's liable because you brought him a case of beer or baked a pie or whatever the case may be. We would be completely eroding the statute.
But if he's taking care of the uncle all of the time, that would be more like compensation, wouldn't it?
I think the existing case law would still note a distinction there because they were requiring a clear nexus. I mean, I would think paying a fee to be a member, if that's not consideration, how can occasionally mowing the lawn? And he didn't say he did it all the time. And I think that's important. He just helped out when needed, as did his older brother, as did other family members, because my client allowed them all to use this property. He no longer could hunt, and he gave them the keys to the cabin and let them use the property as they wanted.
Anything further, counsel?
No, Your Honors. Thank you.
Okay, so case 532, Montegary versus Miller.
All set.
May it please the court. Doug Wagner on behalf of the defendants. This court should reverse the denial of the motion to dismiss, vacate the jury award, and enter judgment in favor of the defendants in full. Starting with the equal protection claim, that claim should have never passed the pleading stage because under the U.S. Supreme Court decision Enquist, selective enforcement claims under the Equal Protection Clause are not viable in the public employment context. It's certainly true that the language of the opinion was confined to class of one claims, But as the majority of district courts within the Second Circuit have held since Enquist, the logic of Enquist covers selective enforcement claims.
I'm going to ask you a really technical procedural question that comes to mind in this appeal. That argument that you're making, is that based on your appeal from the judgment itself, the final judgment?
It is based on the appeal from the final judgment, but it is because the motion to dismiss denial is brought up for review by virtue of the appeal from the final judgment.
So there was actually an order denying your motion?
Yes, but I must clarify a little more. There was an order denying the motion to dismiss without prejudice for our legal arguments at the motions to dismiss stage. We then re-raised all of our legal arguments at the summary judgment stage. And at that time, the judge denied our purely legal arguments on the selective enforcement claim. So I guess to be hyper technical, it is that the summary judgment order comes up for review to the extent it is based on purely legal issues.
For the final judgment?
That's right.
Give any thought to whether or not the Court of Appeals decision in Bonzar precludes the review of that summary judgment decision because it didn't take any issues out of the case? I think you know what I'm talking about.
I know exactly what you're talking about, Your Honor, and I've given much thought to this. So Bonzar's point is that issues that litigants have the opportunity to litigate at trial do not necessarily affect the final judgment, and therefore those issues do not merge into the final judgment appeal and would not be reviewable. But the difference here is that these are purely legal issues, and we've cited in our brief cases like Cianci and Costia, where this court and the Second Department have said the purely legal issues are really motions to dismiss under 3211, even though they're at the summary judgment stage, and therefore those issues can still be reviewed even though there's been a trial.
And at trial, did you make this motion as part of any trial motion?
No, so we did not make a trial motion related to selective enforcement, nor did we need to. And it wouldn't make sense for us to, because the motions for a directed verdict under 4401 and 4404 are about the legal sufficiency of the evidence. They're about whether the jury was able to make the findings they made. But here,
don't we have a problem here with this verdict sheet and the combined damages in the verdict sheet? And how are we supposed to determine, what the jury was thinking? It's a very confusing verdict sheet.
I agree, Your Honor, that the verdict sheet is confusing, but at least as to this issue, whether or not there's a viable claim for selective enforcement, the verdict sheet is irrelevant.
But aren't there combined damages in some of these questions on different legal theories, like the retaliation and the other claim that was made too on some of those questions? So we don't really know because they weren't separated. The interrogatories weren't separated the way they're supposed to be.
That's correct, Your Honor. And I would note that we did submit a different verdict sheet. It can be found at NYSEF docket 244. So to the extent there was error, it was not on the defendants. But I would also hasten to add that should we prevail on all of our arguments on appeal, the verdict sheet also becomes irrelevant because the entire verdict sheet would be thrown out and the defendants would be entitled to a full judgment.
Okay.
As I was originally saying, the district courts in the Second Circuit have the majority have held that this claim can't survive after Enquist. And the reasoning is clear because the Enquist opinion says that in the public employment context, there can be decisions made for a good reason, a bad reason, or for no reason. Essentially, it's at-will employment. So in Enquist, it had to do with arbitrary decisions. Here, it has to do with malicious decisions, but both are either good reasons, bad reasons, or no reason. We also know that because
just to follow up, if we agree with some of your contentions, but not all, what's your position, how we should handle it? Like there's the argument that this should have been brought to the court of claims, some of these arguments that they're not viable against the defendants here. What's your position on that?
Well, so if this court were to agree that the tortious interference claims should have gone to the court of claims, the plaintiff and claimant in that context has already had an opportunity to bring those claims, but they were dismissed for a lack of timeliness. And so that issue would be settled. But to take Your Honor's question as to if there are line drawing problems, I think the correct answer would be a new jury trial, because if this court cannot discern where the damages came from and we win a split judgment on appeal, then a jury trial might need to be rehabbed, or at least a jury trial as limited as to damages.
But counsel, just to go back for a second, what about the case of Air Day versus City of New York? And there the court said that selective enforcement of the claims after inquest do survive.
Airday is incorrect, and it's certainly in the minority in the Second Circuit. Airday on appeal, the Second Circuit did not reach the issue and decided to leave it open, as it also did in Who. But I would point out that the reason that Airday is wrong is because malicious reasons fall under bad reasons, and arbitrary reasons fall under no reason. And the U.S. Supreme Court in the question presented was asked, can malicious or arbitrary reasons support an equal protection selective enforcement claim, or equal protection claim? And when the Supreme Court issued its decision, it affirmed the vacating of the jury award in full, and it did not draw a distinction between malice and arbitrariness. If Your Honor cared to listen to the oral argument in the case, Justice Breyer and many of the justices were all asking, what if an employer simply doesn't like an employee? What if they're just saying, I'm demoting you because I don't like you? And the answer in the opinion was, that's allowed. Even if this court doesn't want to reach that issue, because it is an open question in the Second Circuit, the defendants were entitled to qualified immunity on the issue. Qualified immunity attaches when law is not clearly established. As this discussion shows, this law was not clearly established. It's an open question in the Second Circuit. Plaintiff has pointed to no cases in this department that settle the question.
Anything further, counsel?
I have much further, but I will jump to any. There's the retaliation issues, that the tortious interference issues. Does the court have questions about either of those in particular?
No questions regarding those, but be mindful of your time.
I understand. I'll just jump to one final point then on the tortious interference claim. Even if this court thinks that the tortious interference claim could have been brought in Supreme Court, a directed verdict was proper. As we pointed out in our brief, that's because the investigation moved forward through the normal processes. This court decided a similar case in Vendetti, and I just want to leave this court with a quotation from Vendetti. The court said, indeed, the uncontroverted fact that plaintiff violated DOT's computer use policy established a non-malevolent motivation for defendant's challenged actions. And that's the case here. The complaint established a non-malevolent motivation for the actions. So the jury verdict saying that the defendants acted solely out of malice could not stand.
Thank you, counsel.
Thank you.
May it please the court, AJ Bossman on behalf of Mr. Montegari. So what the defendants want us to do is to go back in time and pretend that they raised all of these arguments before, during, and after trial. As we pointed out in our brief, they have waived these arguments. They waived the argument, the challenge to the First Amendment. They waived the argument with respect to Marticello being aware of the plaintiff's speech. They waived the argument about the equal protection claim. They waived everything but the tortious interference claim. And the tortious interference claim is solid, both because this jury had a front row seat to determine the credibility and the demeanor of each witness, the plaintiff, and each defendant. And they made a finding, and this verdict should be supported and it should be affirmed. Counsel's pointing out about the inquest claim, as Your Honor has noted, the Airday case found that they have this Leclerc claim, which is selective enforcement. Now, to say that they could discipline or treat an employee any way they want, that at-will thing falls away when it's motivated by malice. So if the government actor wants to suppress constitutionally protected speech or wants to just exert personal malice, that is not a government function. You don't get to say, because I'm powerful, I can pick out my enemies and I can stop them, I can shut them up. The inquest argument fails because the malice-based selective enforcement under the Who decision, that was a public employer, Davis versus Metro North Railroad, that was identified. The class of one is based on a rational basis. The argument here, the theory rather here, was that the selective enforcement involves the malicious intent to treat
an individual differently than those similarly situated. I note that he hasn't argued today anyway, that we have failed to identify similarly situated individuals. If you look back in the summary judgment
So
record,
let me ask you a question. If say we hypothetically agreed with him on tortious interference, but agree with you on selective enforcement, because the verdict sheet didn't isolate these things, how would you suggest we should handle that?
I think defense counsel should have objected at the time of trial, should have raised the issue at the time of trial, should have held the jury, and should have made the objection timely that the jury verdict form was not proper. He didn't do that. The verdict form, and I just.
Both sides consented to the verdict sheet, correct? Or didn't object? Nobody objected to the verdict sheet.
I don't recall if anybody objected to the verdict sheet and during the charge conference when we were going over that. But my recollection is that the jury verdict form went to the jury without the objection of defense counsel, other than the general objections that he raised repeatedly, including reciting vendetti ad nauseum. And that case does not control here. I don't believe that the jury verdict form was confusing either. I believe it was set forth very clearly, and the answers to those questions, when you're talking about combining, I think you're talking about motivated by. I think that motivated by question is what you're talking about, the combination. But we went through that extensively with the judge. And because either or of those things would result in a verdict in plaintiff's favor, it was conceded that that would be the easiest way to get through that. So, okay. So the defendants did not argue until this appeal that the law governing selective prosecution is not clearly established as a constitutional violation. This is new. This was never raised below. What they raised was something else entirely. If you take a look at in the docket, it's not in the record, but our trial brief at docket number 242, we addressed extensively this selective enforcement claim at that time. The argument that the comparators were not adequate flips the burden on its head. The defendants were found by the jury not to have established their same decision defense. So they didn't produce any evidence, which was their obligation, the defense's obligation, to say, well, we would have made the same decision about how we're going to treat Mr. Montegari, even in the absence of his protected speech, even in the absence of that. And the other thing that's getting blurred here, which, throughout trial was very clear, and that is that Mr. Familette did not make a complaint against Mr. Montegari. Mr. Familette made a complaint against someone he saw the day after he had been pulled over. And he identified a license plate. He didn't write down the license plate on the day that he got pulled over. He identified another car in his fleet of cars, which Tori Gianni also was driving one of those fleet of cars, and they never pulled his Easy Pass records. They did that to Al Montegari because Al Montegari was causing trouble within the Department of Corrections in this investigative unit. So I believe that it behooves us to recognize that there was not a civilian complaint against Mr. Montegari. There was a civilian complaint by a convicted felon who saw somebody on the thruway, had apparently gotten pulled over, decided that the person he saw the next day, or the car that he saw the next day, was the same car, made the report to the state police, I think, to avoid a violation of his probation, but that be as it may. What were the adverse actions that were taken against Mr. Montegari? The license plate was found to be close enough. The fleet director said that Mr. Miller came to him and he looked for that license plate number and they didn't have it. And he said, well, that's close enough. Montegari's is close enough, not Torreggiani's. He was threatened if he didn't resign, and he went to a Section 75 hearing, which defense counsel conceded was protected speech. He would be terminated or demoted. He was falsely announced to coworkers to have resigned when he didn't resign. He was accused of lying about his speed, which he didn't lie about his speed. You can see that in the arbitrator's report. He was, they tried to change the complaint from Mr. Famlet. They went to his place of business. They surrounded him. They said, "You sure it wasn't March 6th or March 11th or March 27th? They tried to shoehorn the evidence against Al Montegary.
And that was after it was realized that Montegary was at some kind of a seminar on the date that was originally posted. Is that right?
Yeah. Yeah, so he wasn't even there. And then they removed him from his position, walked him out like a criminal, called him a liar, transferred him to 3 hours away, refused to confirm that he had a job so he could get a mortgage. So he ended up living in a trailer with his wife and kids, and denied him a raise based upon the fact that they brought charges against him. So all of those adverse actions that were collectively done to him by Marticello, by Miller, by Annucci, and I think that the jury made a very discerning verdict in that regard. He didn't really argue whether or not this was protected. I think that it's clear that it is. Again, if you look at docket number 242, there's a number of cases that we've cited in there regarding publicly shared speech versus private speech, and speech protected even when it's related to your work duties.
Counsel, you should begin to wrap up time-wise.
I am. Thank you. And I assume you don't have any more questions. Mansour versus Abrams. Mansour versus Abrams is a case from this court from 1988, 144 AD 2nd, 905. Tortious interference for untrue performance evaluations resulting in injury constitutes a claim. And that was Mr. Abrams, who at the time was the Attorney General of the state of New York. Thank you.
Thank you, Counsel. Case 533, Cassidy versus Livingston County. Proceed, Counsel.
It please the court, Ryan Lima from Phillips Lytle LLP on behalf of the appellants, Livingston County and the Livingston County Sheriff's Department. Your Honors, this appeal presents a straightforward question of statutory authority. Civil Rights Law 50B declares that the identity of victims of sexual offenses shall be confidential, and no public officer may disclose any portion of a police report or other document that tends to identify such a person unless they've made a showing, or rather except as provided in subsection 2 of the statute. Here, subsection 2B permits disclosure upon a showing of good cause, but only if that application is made on notice to the victim and to the prosecuting authority. The trial court below here acknowledged that notice requirement, but excused it in this case, declaring it to be an
What did the trial court below do here? Was it not to arrange for an in-camera inspection of the documents?
That is correct. The first.
Now, are you arguing that by ordering that, by having an in-camera inspection, that's disclosure? You're not arguing that, right?
Well, yes, I do think in the People versus Doe case from Monroe County makes this point that literally construing the statute and in-camera review will in fact be disclosure in violation of the text of the statute and being.
So that is your argument. Your argument is the mere fact that the judge ordered an in-camera inspection, that violates the disclosure rules.
That's my argument in part. The other,
before the judge even makes a determination as to whether maybe nothing that he's reviewed or she's reviewed is disclosable.
That is one portion of my argument, Your Honor. The other point to make is that the in-camera review, the court's decision to waive that notice requirement is essentially final in our case as a result of this order. That's not something that's dependent on further in-camera review. And so this was the appropriate order to appeal at this stage of the case. Counsel has argued that this appeal was premature. And for the reasons I just articulated, I don't think that's accurate. But if the court disagreed, I think the path forward here, as the Roswell case that plaintiff cites from the second department makes clear is to simply treat this appeal as an application for leave to appeal and proceed to the merits in the interest of judicial economy. And so we encourage the court to reach the merits there, because I do think the court's decision to dispense.
Is it one of the options that our court has is to order that the appeal is dismissed and allow the court below to do the in-camera inspection and make a determination as to whether anything is disclosable?
So I don't think so, Your Honor. I would
What would
encourage.
be wrong with that determination?
Again, I think even an in-camera review does violate the text of the statute. We simply cannot disclose the identity or any portion of a record containing information that tends to identify a victim without violating the statute and arguably subjecting a county to liability under 50C. So I do think that's improper. And again, there's nothing that would come out of an in-camera review that would change the determination about whether or not the court had authority to excuse compliance with that notice requirement up front when plaintiff made this motion to unseal the redacted victim identities. That's plainly error under the text of the statute. I think, statutory interpretation here, beginning with the plain text, we have an unambiguous mandatory command that any application under subsection 2B shall be on notice to the victim. That's in mandatory language, and every authority to have even touched upon subsection 2B's exception has found that that language means what it says. The Court of Appeals in the People v. Weinstein matter denied a motion to intervene seeking to unseal records purely on the basis that the moving parties had not made their application on notice to the victims. The Doe versus Ryback case, I think, is on all fours, where there were applications for non-party victim materials that was denied both under the public interest privilege, but with respect to the 50B issue, the court found that the movement's failure there to make his motion on proper notice was itself fatal to the application, and the court needed to go no further. Again, plaintiff hasn't found a single case addressing subsection 2B where a court has excused non-compliance with that mandatory notice provision. And so instead, plaintiff has rested his argument on this one judge concurring opinion from Judge Wilson, in the Marion T matter. As we highlighted in our reply brief, the majority of the Court of Appeals in that case applied the statute exactly as it was written, which is the result that should follow here. The legislature has made victim identities confidential as a matter of public policy and constructed these limited exceptions in its gatekeeper function, and the trial court wasn't free to rewrite the statute in its own judgment. There are important public policies behind the lines that the legislature has drawn with respect to the personal privacy of non-party victims here, forcing them to recount their trauma if they're drawn into this litigation, and the chilling effect that could potentially have on other victims coming forward in the future. Ultimately, I think that the Deborah S. decision cited in the briefs, there's an extensive discussion of the statute in that case, considering it as an issue of first impression. The choice for a victim whether to come forward is ultimately should be the victim's choice. And plaintiff, I think, would put the cart before the horse here, and without prior notice to any victim would have their identities unsealed and would, send investigators or subpoenas to them.
No. See, that's where you kind of lose me. I'm understanding your argument being that this all applies to with the judge doing an in-camera inspection. You're jumped off of that into an area of having the records unsealed and distributed and made public. That clearly, I understand that argument, but your argument is having to do with the judge doing the in-camera inspection. Right? Isn't that really your argument? Because that's the status of the case.
In any disclosure that flows from that in-camera inspection would be in violation of the statute and the lack of notice.
We're not there yet. We're not there yet, right? Because the judge hasn't even done the in-camera inspection. It hasn't ruled on anything. And there would be relief there for you if, in fact, the judge was making a determination as to unsealing and making these records public, right?
Again, I do think even the disclosure to the court for in-camera review, as the court in the People v. Doe case found, it violates the statute. But practically
that's
speaking,
your argument needs to be, though, right? It doesn't need to be. It can't be on what's going to happen when these records becomes public, because I don't know how that's before us.
Well, as a practical matter, there's not necessarily another vehicle to bring this up for review following whatever the court may do after.
If this goes back to the judge and the judge does the in-camera inspection and makes a determination, isn't that? Don't you have an opportunity to take a look at that?
I don't know that that results in an appealable order, Your Honor. And that's why I think the appeal at this time is the appropriate procedural juncture to raise the issue. I would move on to, beyond the failure of notice, which I think right there, it was reason enough for the trial court to have denied the motion without proceeding any further. But I think under the circumstances, plaintiff also failed to demonstrate good cause. What that means is going to vary by the facts of any individual case, but it of course has to mean more than just the material and necessary standard under Article 31. I would submit that it needs to be balanced against the victim's privacy rights that are protected in the statute. Here, plaintiff already has the substance of the sheriff's investigation file. What's missing is identifying information with respect to these non-party victims. Pursuant to plaintiff's own testimony, the summer at issue where he was working at the dog control facility and was abused by Mr. Walker, he was the only young person employed at the facility that summer. In other words, there were no other concurrent victims. There were no other people who were direct witnesses to anything involving the plaintiff and Mr. Cassidy. Really what plaintiff is...
But I'm just following up on one of PJ's question. Like, wouldn't it follow the spirit of the law if the lower court reviewed everything, didn't disclose anything, and tell the opposing party there's no reason to disclose anything? Then that way you would never have to contact the victims and they wouldn't have to relive that trauma.
But all that's been redacted from these documents, Your Honor, is their identities or information that would tend to identify them, which is what the statute provides. So I don't know that there's anything to be gained from further in-camera review at this point. The court has already made the decision that it can go ahead and review these records and the victims' identities and then potentially make further disclosure without them having been placed on notice as the statute requires.
And again, I'll let the PJ speak for himself, but I think that's kind of what he was alluding towards. They didn't do anything. The lower court didn't do anything. They just asked for the records.
Well, the lower court has already decided this motion not made on notice to the victims as the statute requires. I'm nevertheless going to order the county to turn these records over for further inspection and potentially further disclosure. At that point, the court has run afoul of the statute, and that is reversible error.
And that's something we have to take a look at. And we understand that argument. Anything further, Counsel?
Just briefly, there's a separate basis for reversal of the public interest privilege that shields confidential communications to or between government officials where the public interest suggests that information disclosure would not be in the public interest. That has routinely been applied to statements by victims or witnesses to law enforcement, described as well settled in the Melendez and Rodriguez cases. Doe v. Ryback, again, is a case very similar to what's presented here, where the court denied disclosure both under 50B and the public interest privilege based on the application of that privilege to statements given to law enforcement and the potential chilling effect that disclosure of those types of records would have.
Thank you, Counsel.
Thank you.
Morning, may it please the court. Craig Bernhardt from a law firm appearing on behalf of the plaintiff respondent, Your Honors. The court below has broad discretion over the discovery process, and absent a clear abuse of that discretion, the decision should not be disturbed. What the court was faced with below was statutes in conflict. CPLR 3101 specifically says that there shall be full disclosure of all matter, material, and necessary to an action. We sought to enforce that discovery device. Defendant raised the Civil Rights 50B law. Those statutes conflict because on the one instance, we have the right to discover the names of witnesses in the underlying civil action, which would make these identities discoverable. 50B states that identities of victims shall remain confidential. So the court had to apply a balancing test of these conflicting statutes and make a just determination weighing the rights of all the parties. Now, as the court's pointed out, the court below has not gotten there yet, which is why we felt this was premature. Court below asked for an in-camera review of these documents so that the court can see what is there. The court below actually rendered a decision, I think, indicating that it appears that more than just names have been redacted from these documents. The court below needs to see what these documents say in order to make the appropriate analysis. The court below said, I cannot engage in this weighing of factors because I don't know what the documents say. I need to see what they say so I can appropriately weigh the competing interests and then make an appropriate determination. Now, what we don't know is what the court below is yet to do. But the court below has multiple options available to it. Perhaps the court below feels that the names are not discoverable and we don't obtain them. Perhaps the court below believes they are, that the need for them outweighs the Civil Rights 50B issue. And in that instance, the court below could implement a protective order, a confidentiality order. Only the attorneys have the identity of these individuals. The court below could direct that the police agency send a notice to these individuals that your identity is being sought. You have the right to come into court and be heard anonymously. We don't know where the court below is going yet, and that's why this is premature. But the point being, the court below has several options available to it in weighing these competing factors. Certainly, no law, it would be to think that this law exists to protect the enablers of childhood sex abuse is certainly not what anyone intended. And if we apply the law as the way my opponent would have us apply it, the enabler of the childhood sexual abuse is protected. I'm certain that these victims would want the opportunity to ensure that that doesn't happen, that these enablers are not protected. I would also draw the court's attention to page 77 of the record. That is the first page of an incident report. Page 80 of the record is also the first page of an incident report. Page 77, first page of an incident report, the date and time in the upper left corner are redacted. So we're not talking about just names being redacted. On that instance, there's a date and time of the report redacted. Court below, again, asked for unredacted disclosure of these documents so that the court below can assess what it is that has been redacted and then make a determination as to what we are or are not entitled to. Absent any questions from the court, rest on our papers.
Thank you, counsel.
Yeah, thank you, Your Honor.
Case 534, Newco Capital Group versus Logan Marketing Group. Counsel, can you hear us?
Yes, Your Honors. I can hear you. Can you hear me?
And we can hear you very well. Please proceed.
All right, thank you, Your Honors. May it please the court, Ariel Buskila of Berkovich and Buskila for the appellant, Newco Capital Group 6 LLC. I would like to start just briefly understanding or explaining the fact that the judgment at issue here was entered pursuant to a stipulation of settlement, which provided for entry of judgment in accordance with CPLR 3215I. The standard that was used both in the respondent's motion to vacate and in the court's ultimate decision really pertains strictly to vacating or modifying judgments that were entered on default or failure to answer by a party. We have case law that we've cited that specifically states that when we're dealing with stipulations of settlement, they're not going to be disturbed unless you have some sort of fraud or collusion, mistake or duress or something along those lines. Because of that, the court, in using the standard of the interest of justice or in their discretion, vacating or modifying the judgment or opening the judgment was improper. With respect to the actual, even if that framework was proper, with respect to their actual contentions, the court was noting that there was some ambiguity or that there was some discussion in terms of settling the case on behalf of the guarantors in exchange for the assignment of these receivables to non-party libertas. But the settlement agreement or the post-judgment agreement, which we've which is what we refer to it on appeal, the PJA was strictly releasing the guarantors and Logan Marketing only in the event that NUCO actually collected that $325,000. And that was clear both by the language of the agreement and contemporaneous conversations that were had by and between the parties. And because of that, yes.
Counsel, let me just catch up for a second. Addressing your point initially about the judgment that was entered based on a stipulation of settlement. As I recall that section, it allows for an affidavit to be provided that says, here's how much they promised to pay, here's how much they pay, here's the net number, this is a liquidated number, the liquidated amount, therefore the clerk can enter judgment because it's a liquidated amount, right?
That is correct, Your Honor.
Okay, so even though there are payments, it doesn't change the fact that the net amount is a liquidated amount that may be entered pursuant to based on a clerk's action as opposed to a judge's action.
So that is correct, that it is based on a clerk's action, and the liquidated amount can be reduced by payments made. So hypothetically speaking, I think in this case, the settled amount was about $1.3 million. If there were payments on that $1.3 million, the amount that the judgment would be entered for would be the $1.3 million less any payments.
Got it. So dealing now with the $1.3 million default judgment that was entered based on the stipulation of settlement, again, pre-judgment that resulted in the default and the default judgment. So that number, do I have it right, was ultimately compromised by your client to go from $1.3 million for which they had a judgment against the guarantors to $325,000?
That is correct, Your Honor. We agreed to accept a very reduced amount because of, there were some other issues, not really before the court, but there were issues with the business and with the amount of money that would have been available. So
okay, so bear with me again. So I'm just trying to follow it through. If that $325,000 had been collected and paid to your client, then the release for the respondents would be effective, correct?
That is correct. And that $325,000 was never collected and never received by NUCO.
And even though the post-judgment agreement makes no reference to a satisfaction piece, as you point out in your brief, the satisfaction piece, if you hadn't provided voluntarily, could be compelled by a court under 5021-2, whatever it is, or
CPLR 5021,
or deemed satisfied by a court order. So
that is correct, Your Honor.
If they paid the $325,000, the remedy was ask you for a satisfaction piece of the judgment, and if you didn't provide one, make that motion as you point out in your brief.
That is correct, Your Honor. So okay. I was going to get to that. So the entire procedure of filing this motion to vacate the judgment is procedurally incorrect. And that goes to one of the second issues that the lower court paid attention to, which was saying that in the interest of justice, this would be a waste of judicial resources to leave the judgment and then require them to file a plenary action. But we're not saying that they needed to file a plenary action, because if they deemed themselves satisfied, if they fulfilled their obligations, they would have been able to make a motion under 5021, like Your Honor mentioned. But going back to the court's first point, that there was some form of ambiguity whether or not we released the guarantors by virtue of entering into this judgment, which was entered prior to the settlement agreement, 2 months before, 5 months before nearly, there was no ambiguity. The settlement agreement specifically stated that any release or any requirement or any UCC termination or anything of the sort was only required and expressly conditioned on NUCO's actual receipt of the $325,000. And as we noted, the settlement agreement provided for an assignment of roughly $1.25 million in receivables to a non-party Libertas who was charged with collecting that. There was a separate agreement entered into between NUCO, Libertas, and another non-party, which would really pertain or which discussed how we were splitting the funds. And if we received $325,000, then the guarantors would be released. We never received the $325,000. And because of that, the guarantors were not released, and we were permitted to enforce the judgment. I would also note that opening this judgment.
I'm sorry to interrupt you again. Don't forget where you are, but just so I get this question out, and I don't forget about it. In terms of the default judgment being payable, you always retain the right to collect it, right? So I guess my point is that right didn't go away even now, correct? Nothing has changed. You still have liability. So I think, in fact, is the interest clock still running because you have liability?
I believe the interest clock is still running, but my understanding, because liability was remains, but the amount is in question, and that amount may be zero, the court noted, it really prevents me from taking further action on it, which is what prejudices my client.
Now, does it change your priority vis-a-vis your judgment in Pennsylvania?
I believe that it does. And I think that the judgment in Pennsylvania has essentially been mooted, which is permitting the guarantors to dispose of their properties in Pennsylvania.
Even though the judgment's there?
Even though the judge, well, we're not, my understanding based on the order here is that I can't actually do anything with respect to the Pennsylvania judgment.
But as I read it, the court didn't direct you to vacate that Pennsylvania judgment. So based on my reading the record, that judgment of Pennsylvania is still there. You still have liability. And as you indicate, the interest clock is still running.
I guess that could be true, Your Honor.
Okay.
If the court has no further questions, I can rest the rest on my brief.
Very good. Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court, David Benz, the Cheney Law Firm, appearing on behalf of the respondents. Our position really comes down to two major points here, Your Honor. First is that we believe that the lower court did possess and chose to execute on its inherent discretionary powers to vacate this judgment, essentially taken, whether you want to call it by default.
Here's my concern. It's the point that's raised in the appellant's brief, is that it looks like what the court based its decision on vis-a-vis the judgment entered upon the default under the stipulation of settlement. What the court was doing was based on post that judgment conduct, correct? And if that's the case, I think the case law says the court can't do that. And I suspect that rule, if it exists, is based on the idea that, hey, if you don't let people negotiate after a judgment, they can't get the deal that your client got, was to buy off a 1.3 million judgment for $325,000. So isn't that rule apply here?
In a normal, I think CPLR 5015 context, yes, but I think that the court's discretionary power goes beyond that in unique situations that basically doesn't have this limitation. It says it's in the interest of substantial justice, and that's the argument here, is that we've got a unique situation in this case.
All the court really did was seemingly stay the execution of the judgment, correct? Because you heard my questions of your colleague there. Do you disagree with any of the conclusions that I'm reaching based on this record? That is, liability remains in effect.
That is correct.
As a result of that, the interest clock remains going, right?
That is correct.
And the Pennsylvania judgment is unaffected vis-a-vis its priority.
Correct. Yeah, so essentially what it does is it preserves the liability aspect, but it comes down to a question of, okay, you've got liability, but now perhaps the dollar amount we're talking about, has that been satisfied by the subsequent arrangement that occurred between the parties at a later date? And
one could argue Supreme Court has given the parties some breathing room on a number.
Potentially, I suppose, yes. But you have a unique situation here where because they have a stipulated settlement, admittedly, there's no question. At some point in time, that there's, again, no question of the fact that they defaulted under that stipulated settlement. Judgment, for whatever reason, the way they drafted that language says that they don't have to be provided notice, the fact that that judgment is going to be entered against them. And the court below found, based on the evidence submitted, that the fact that that judgment had been entered was never provided, and notice entry was never provided to my clients. So one, there's no evidence that was ever served on one, and the other one, it went to a bad address. So they had no knowledge of this. So then fast forward, they go into the situation where they're trying to work out this resolution, and in the back, in NUCO's pocket, they already have a judgment. They, for whatever reason, choose not to mention it exists, and they negotiate this new deal that talks about, well, you're going to pay $125,000 cash. You're going to assign your accounts receivables valued at least $1.25 million over, and then this weird arrangement whereby another third-party creditor is going to take lead in trying to collect on things, and then it comes down to, I guess, a question of what efforts do they have to take to collect, over what time period, and based on that, I think the court found that there's a question of intent and ambiguity in the contract, because you could have a potential for collusion or abuse, wherein one creditor says, okay, we tried to collect, we couldn't collect on $325,000. So now we've already obtained $125,000 cash. We've gotten all your receivables now, and we still have the benefit of a $1.38 million judgment against the guarantors. So now we're essentially not complete double dipping, but we're recovering more than we're entitled to because we can go back and forth and pick our avenue of recovery. And my clients are saying that clearly this, if they had known of the fact that this judgment was here, obviously the intention would be that this would be wrapped into this. And unfortunately.
They could still apply under 5021, as the other side points out in their brief. You could have easily made a motion. If you didn't get the satisfaction piece upon paying the 325, you could have asked for the satisfaction piece. And if they said no, you could have moved to compel it and or have the judge determine that a satisfaction will be filed by virtue of its order, right? I mean, this is curable easily in another way, isn't it?
I suppose it is, but I mean, we're dealing with what the judge determined to do in this situation, and the judge indicated in this situation it made sense to approach it this way. And we believe that this is still a viable way to address the issue.
Anything further, counsel?
Nothing, Your Honor.
Very good. Thank you. Case 538, Lignetto versus AMP Marine Services, LLC. Justice Greenwood is recused.
Good morning, Your Honors.
Counsel, proceed.
May it please the court, David Birch, Barclay Damon LLP, on behalf of appellants.
Jumping in on this case at the last minute.
Jumping in on the case. I have been involved throughout.
Oh, you have? Okay, very good.
It's not a complete pinch hit situation, but yes, my colleague got held up in a jury trial.
In a federal trial, right?
Yeah.
Yeah. All right, proceed.
Thank you, Your Honors. Appellants request this court reverse summary judgment and remand to the trial court for further proceedings. You'll see from the record, there's two separate easements at issue. The two appellants are not similarly situated.
I have the hardest time reading the maps in the record. I'm sorry to complain, so to speak, but I mean, you tell me it's there, and I guess all I have to take is the party's words for it, that it says what you say it says, because I can't read it. Yeah. And I use my glasses, I use a magnifying glass, I did everything I could. Yeah. So you're telling, the parties agree as to what the easement says in the deed?
I think, Your Honor, if I could get to that.
Go right ahead, please.
I think the deeds are clear. My client, Guy Hart, his position is that.
I was referring to the maps. I'm sorry to get you off your game there. Go ahead.
Yeah, his position is that map's not clear, that it doesn't put him on notice that there's going to be a later, provided easement across the property that he bought. So the sequence is that this property is subdivided in 1987, right? The marina had been unified with this back parcel, subdivided in 1987.
And sorry to interrupt you, but I'm in the same boat as Justice Curran in terms of trying to get my arms around exactly what happened here, because what I did is I went to the map to try and understand what's going on. Mm-hmm. Let me just ask a question, because you're now referring to the subdivision plot map, right? Yep. Okay. And looking at that, when I look at, we've got lot 2, which is south, lot 2 north, lot 1 south. And then if I'm looking at lot 2, I'm looking at to the east 3 separate properties.
Correct.
Right? And to the west, the AP property. I've got that right so far, right? And so the easement, because as the argument goes, the owner of lot 2 has no access to the property without the easements. And there's 2 easements, of course, we all know are in question here. The Hart easement and the AP easement, right?
Correct.
All right. So you're going to think this is a silly question, but is there a portion of the property south of lot 2 that borders lot 2 and Broadhead Road?
Correct.
Is there a portion of the property? Is that the portion that we're talking about?
If you're talking about the plaintiff's lot 2, that doesn't border a public road.
It does not border a public road. So, and there is a public road in proximity to that. That's Broadhead Road, right?
Yes.
Right.
It's not particularly close, but that would be the closest road. But none of those other properties border
Broadhead Road.
Correct.
And so all of those properties need an easement they're trying to get to Broadhead Road, right? So that they have access to their property.
I don't know what they're trying to do.
Well,
there,
I mean,
but-
let's be frank about what's going on here, right? They've got this property and they're trying to access it, and they've got arguably these easements. And so the easements would cover the property, the distance between the southern border of their property, just to be safe here, and Broadhead Road, the northern portion of Broadhead Road.
Good, correct. Setting aside the lake access and all of that. I mean, this is not just a landlocked parcel.
Yeah, I guess they could access it by boat, sure. Okay, go ahead.
And so, getting to the map, 1987 easements created, there's these other residences subdivided off, they get their own easement properly recorded. Then you get to 2020. Subdivision map filed. It does say the Melfi subdivision map. It's filed in the county clerk's office, that's not disputed. What is disputed is there's no document filed before that that created that easement. There's no deed, there's no easement grant, there's nothing. It's just a map that has drawn in an easement. But of course, there's all these other easements that go across to all of the other parcels that have been subdivided in the subsequent years, or the intervening years between 1987 and 2020.
That map, though, predated your client's deed.
Yes, it did.
Your client's deed references that map? No, it doesn't.
It does not
No, it
reference
doesn't.
that.
But it was available to him because it was public record.
It was available to him because it was public record, but not referenced.
Yeah.
Not referenced in his deed. And then 3 minutes after his deed gets filed, the seller that sold to Mr. Hart records a deed to themselves creating the easement. And it's typed in different font at the bottom of that Schedule A. That's in the record, in or around page, record 58. And so Mr. Hart's position is he didn't have actual notice and he didn't have constructive notice that Lot 2 was going to have an easement through his property. Because of the sequence, because of the allegations that he was on notice in different ways, this was a vacant parcel up through the date this decision was entered.
And without notice, your argument is without notice, the easement has no power over his fee simple.
Correct, because it was recorded thereafter. And I'll rest on the cases cited in my brief for that law.
What about AP? You're representing AP also.
So I'm also representing AP Marina. AP Marina.
All right, let me stop you there with my questions about my mental map, okay? So is AP Marina's property the property that's located next to Lot 2 to the west? Or is AP's property actually across a body of water?
It's across a canal, across a body. So there's Oneida Lake here, then there's a canal.
So there is a piece of property that's just west of Lot 2. That's not we're not talking about that property.
That's
not AP's property.
That's not AP's property.
AP's property is closer to not Broadhead Drive, but rather, what is it, West Murray?
Yeah, West
right?
Murray Drive.
That's where AP's property is located.
That's right.
And that's across the body of water.
Correct. And
Okay.
Mr. Hart owns that parcel between the canal and Lot 2.
Is that part of Lot 1?
Yes, that's all one big lot.
That's all part of Lot 1. What isn't
residence?
Lot 2 and those other those other lots to the east of Lot 2, everything else is Lot 1.
Correct.
That's helpful. Thank you.
And then, so where you see the canal on the map, and then there's the easement drawn in, and then it ends at West Murray Drive. That's the marina property.
I've got it now. Thank you. Proceed.
And so that's the property that respondent wants to traverse. She wants to traverse from Lot 2 across Lot 1, which is Mr. Hart's property, across the canal where there's a bridge, and then through the whole marina to West Murray Drive. And she's relying on this 1987 easement that was created when Lot 1 and all these other lots were unified as one parcel with the marina parcel. And when they were subdivided...
I'm going to stop you again only because how confusing it is. So you're saying the AP easement would run from Lot 2 across AP's property, which is directly west of Lot 2.
I think it stops at the canal at Lot 1.
And so practicality speaking wise, there'd be some type of road that would go across AP's property to a bridge.
Correct.
Across the bridge, which is now again on AP's property.
Correct.
And then there'd have to be an easement to West Murray.
Correct.
All right, I do understand it a little better now.
Yes.
Thank you.
And so that first part across Lot 1, that's the easement we talked about first, across, she alleges, Mr. Hart's property, and then the other easements from the bridge all the way through the marina to West Murray Drive.
Is AP.
Is AP. Created in 1987 when that unified parcel was subdivided so that the then owners could sell the commercial marina off, and they had one building on that unified parcel across the canal that they wanted access to. That's what they created. And now in all of those intervening years, there's been agreements reached with other property holders about various things. Those are not at issue in this lawsuit. Then along comes respondent, and she's relying on that original 1987 easement, which is a 15-foot wide easement through an entire commercial marina across a bridge that the marina, maintains. And at the time the lawsuit was filed, won't answer what she wants it for.
Does AP own the bridge?
Yes, I believe so.
Okay.
And we submit that the lower court should have examined whether this was going to overburden the easement. The lower court improperly.
How would that be? I didn't get the overburden argument really well, and I'm sorry, but how would it be overburdened by having this easement over, so apparently the respondent can traverse the bridge?
She can, drive through the entire marina property and then traverse the bridge. And create all kinds of traffic. At the time, we did not know what she was using the easement for, why she needed it. We sought discovery about those issues. We now know, not in this record, but just to round out the picture, she's constructing a residence there and has all kinds of construction vehicles going back and forth. And we submit that there should have been an inquiry to that at the time that the court made the decision at the trial court level. We did. The decision improperly says we never raised it. It's the fourth affirmative defense. It was fleshed out in our response papers of the motion for summary judgment. There should have been discovery on that issue so that it could have been determined, because that is a concept in the law that just because there's some prior easement granted to a predecessor in interest doesn't mean it's, you can build a superhighway across that. There's some balancing that has to happen, some level of inquiry, and that didn't happen here at all.
If the easement with respect to AP didn't exist, how would the respondent get to the property, Lot 2?
The lake. The lake.
A Hobie Gap.
Yeah, correct.
Okay.
Or a snowmobile in the winter.
Thank you, Counsel.
Thank you, Your Honors.
May it please the court, Janet Callahan for the plaintiff, and thank you for asking Mr. Birch those questions about what the map means, because he explained it a lot better than I ever could. So we've got two different easements or rights of way here. First, I'll talk about Mr. Hart's. Mr. Hart's objection is to the fact, he says he did not have notice of this right of way because the right of way itself wasn't specifically noted in his deed, as it was in the other deed when the Black Knights conveyed to the other Black Knight organization. But there's two things in his deed that did put him on notice. And number one is on the first page, it says it's subject to easements, covenants, and restrictions of record, if any. But then if you take a look at the third page, it's page 61 of the record, in the description of the property that's being conveyed, it says, all that tract or parcel of land situate in the town of Cicero, being more particularly described as Lot 1 in the Melfi subdivision final plan, subdivision map filed in the Onondaga County Clerk's office. So he was on notice that the property that was being conveyed to him was subject to what was on that subdivision map. If you accept the defendant's argument then the only way that you can ever have an easement is if it is specifically contained in a deed. And if specific reference to that right-of-way or easement is not contained in the deed, you don't have one. And that's not the law. You can have a deed that's in a subdivision map, and as long as the existence of the subdivision map containing that easement or right-of-way is in the deed, then the buyer of the property is under some sort of obligation to go take a look at that and can't ignore it and then say, I didn't have notice. I didn't have notice of that right-of-way. Another thing I think is important is the fact that there are these 3 properties that are located to the east of the plaintiff's property. They also rely on this right-of-way, the right-of-way over Mr. Hart's property and the right-of-way over AP's property to get to their properties. Now, Mr. Hart bought his property in 2001.
Counsel, I am going to ask you a math question. And I apologize in advance. Currently, the 3 properties, 3 parcels located just to the east of Lot 2, they have been using a road to get to Broadhead? Right? Is there a separate road that gets to Broadhead from their property, even if it's a really short one?
I believe, I honestly, I cannot answer that question. My understanding is from what's in this record that they have to access both the A&P right-of-way and the right-of-way over Mr. Hart's property in order to access their properties.
So do they have to go over any portion of Lot 2 that you know of?
No.
They don't?
I don't believe so.
Okay.
No, I don't believe there's a right-of-way over Lot 2.
Okay, so they're exercising their rights to use the easement that Lot 2 is now looking to use.
Correct.
Yeah.
And that has been the case since Mr. Hart bought this property, which was in 2001. No complaint was ever raised, no challenge was ever raised to the right-of-way, and it wasn't until February of 2024 when the plaintiff bought her lot that this was raised for the first time. So I think, one of the issues is he did have notice because he had notice of the subdivision plan containing this easement. And also, for 2.5 years, this easement was being used, the right-of-way was being used by the owners of the 3 parcels east of Lot 2, and no complaint was ever made. He also had raised the argument in his brief, Mr. Hart did, that, well, when I bought it was vacant property, and so I didn't know that anything was ever going to be done to develop it. Well, the fact that it was vacant property when he bought it doesn't guarantee that it's always going to stay vacant property, that someone's not going to buy it and develop it. As far as the A&P, there was a 1987 written easement right-of-way. The only proof that we have in this record that the defendant's claim raises a factual issue with respect to this right-of-way is an affirmation by Mr. Keith Atkins. Keith Atkins is currently the owner of A&P, but he's not a signatory to the original right-of-way agreement, which was written in 1987. There's no indication that he's related to anyone who had anything to do with A&P in 1987, or that he has any knowledge of what their state of mind was when they entered into this agreement. He's making 2 arguments in this case, and he's saying, number one, it was intended to be temporary, not permanent. That's belied by the language on the first page of the agreement, on page 29 of the record, where it says that it grants and conveys a perpetual right-of-way and easement. And then his other argument is, well, it was only intended for the benefit of just the beneficiaries of the people who owned it at the time. And that's belied by the second page of the agreement, which is page 30 of the record, where it clearly says that this easement and right-of-way is for the use and enjoyment of such other persons or entities and their heirs, successors, and assigns, to whom or to which the said Donald Broadhead, who was one of the owners, may hereafter sell, lease, transfer, or assign all or any part of the lands to be benefited by the right-of-way. So it goes way beyond just for this one parcel of property. Okay, so as far as the overburdening goes, it's our position that, yes, it was referenced in an affirmative defense in the answer, but if you look at the pleading, what was before the court in this case was the plaintiff's request for a declaratory judgment declaring the validity of these rights of way.
That's all that was before the court?
Correct.
That's all the court ruled on, correct?
Correct. And it's our position that if the defendants, or A&P in particular, wanted some sort of determination or ruling from the lower court about the scope of the easement and whether or not adding lot 2 was going to create an overburden, they should have asked for that. They should have either brought a counterclaim or they should have started a third-party action, because at that point in time, theoretically, the owners of lots, the east lots, I'm calling them 3, 4, and 5, should have been brought into this action because they are parties whose rights are going to be affected by that determination. And just as an aside, there was never any real indication in the record of what is this overburden? What is it about the addition of one more house in this line of houses that all of a sudden is going to create an issue? There were a couple of conferences with the lower court while this motion was being considered. The defendants asked a few times for adjournments, and in between the adjournments, there were court conferences. So after one of these conferences, where the issue became there was a bridge, and whether or not this bridge could handle additional traffic, what about emergency vehicles, can a fire truck go on this bridge? So the plaintiff took it upon herself to hire Barton and LaJudas, and this is in the record at pages 110 through 124. Barton and LaJudas went out, they sent engineers out, they did load-bearing tests, and they came up with a report, and they reported that the bridge was sufficiently safe for legal load-bearing traffic and for emergency vehicles. So to the extent that it has any relevance, the issue of the overburden is in fact addressed in the record. So it's our position that the lower court properly granted summary judgment to the plaintiff, and it should be affirmed.
Thank you, Counsel.
Thank you.
Stand in recess, 2:88.